There are a couple of issues that I want to raise in this particular bill, but the first one relates to the question of a discharge of order under Section 105 for the return of a child, which is Clause 28 of the bill, new Section 122A, being inserted into the Care of Children Act. This relates to a particular case that occurred in my electorate. It was a constituent of mine who had the circumstances where she had her child here in New Zealand, but she had become pregnant while she was travelling internationally. She had the child back here. She made a fundamental mistake. The father of the child followed her back here, persuaded her to return to, and I can't remember which country it was at the time, I think the Canary Islands or somewhere like that, to return with him. She did that with the child, and by the time she decided she needed to leave, it was like 12 months and a few days, which meant that the usual or habitual place of residence was, at that point, the new place, where, of course, the main language that is spoken is Spanish, not English. The father was English, and his mother, helpfully for him, was a lawyer who represented him at no cost, and, of course, tried to track them at the end of the world to New Zealand to bring that child, their only grandchild, back to within their son's area of protection. Now, I mean, it was a very, very difficult case. The whole circumstances of it were quite devastating. In the end, she came back to New Zealand. She actually didn't originally come back to New Zealand forever. She came back for a bit of time out. And then she decided not to return. At that point, the question became where the habitual place of residence was located, and it wasn't located in New Zealand. And even though by the time the father was insisting upon his rights under the guardianship provisions that exist in these circumstances, because both countries, of course, were signatories to the Hague Convention, at that stage the child was, I think, around 4 years old and had spent most of its life in New Zealand, more years of its life in New Zealand and less in a country where their first language was not his own, and he could not speak a word of Spanish. So it was a very, very difficult case, and it went to the court, and the court was extremely sympathetic to the circumstances that were described, and of course said that we had to look to Parliament for a resolution of the problem, because they could only interpret the law as it was. There was no capacity to discharge the order. This, in fact, has the provision for discharging the order for the return of the child, and the grounds are that the court has to be satisfied that the child is now settled in his or her new environment in New Zealand, and, having regard to all the circumstances of the case, the discharge of the return order is warranted, or every other person who was a party to return proceedings consents. But that wasn't an issue in this case because there was no consent, but it was an issue that was of great concern to the family of the child, and some of the wider issues involved. So I'm very, very pleased to see this finally go through. The one criticism that I will have is that it was in the original bill that the Honourable Annette King introduced into the House that sits languishes at the bottom of the order paper, and this could have been included in the first one, but it wasn't, because it didn't meet that kind of, sort of the 100 days of action, sort of mantra that the government used in those early days, which they used for the part of the bill that they did push through very urgently. And so, sort of how long are we since the last election? 2 years down the track, we finally have it going through. But I think that we've waited a little too long for that particular provision to go through. But that being said, it is welcomed. It is a very good piece of law. It is actually reflective of many other jurisdictions. Other jurisdictions who are signatories to the Hague Convention have adopted this practice of having a provision that allows for this to occur. So I'm very, very pleased to be able to speak on the bill because this is a particular concern to me.